Okay, so we've already had one intro class where I just explained about what is company, what is MCA, what is ROC, and all those things, right? So today we are going to start off from the study material, the first chapter. Okay, so this first chapter, Introduction to Company Law. This is your chapter 1. Okay. So, we have already studied about this J.J. Irani committee, if you remember. J.J. Irani committee was the one who introduced Companies Act 2013 to us. Who was J.J. Irani? Any idea? Very good. He was the director of Tata Sons and he was the one who was responsible for this committee. He was the chairman of this committee. So what was the main idea behind this Companies Act 2013? We wanted a shift from government approval regime to a shareholder approval and disclosure regime, which basically means before 2013 Act, we used to be only focused on for everything that we need to do, we had to take approval from the government. But now we wanted to change that system and structure. Why to take approval from the government for everything? When government is, for example, you're a private company, it's your own money. It's your own money which you are using. Then why do we have to take approval from the government for each and every small thing that we do? That is why they told in Companies Act 2013, we don't need government approval from everything. Instead, we will go move to a shareholder approval. Who are the shareholders? Actually, shareholders are the owners of the company. So we will take approval from them, and if anything is required, we will disclose to them. We don't need approval for everything. We should do it and disclose it. Okay. Certain things we need approval, certain things we will disclose. So it is a shareholder approval and disclosure regime. What is the recommendations of this expert committee? Private and small companies, they should have more flexibilities and freedom of operation and compliance at a lower cost. Because otherwise, then people will not want to have companies. People will think sole proprietorship dana podu, partnership firm dana podu. Why to go for a private limited company? Evado costly irke. All the compliances is very, very costly to have a company. That is why they told that what public companies are doing and instead what private and small companies can do, there can be a difference. So for the private and small companies, let us not keep very strict compliances. Let us not give them some freedom of operations. So if a public company is spending, say for example, 10 lakh rupees in a year for compliances, let private companies spend 1.5 lakh rupees. Then only people will want to come under the company structure. Otherwise, smaller business will not want to make a company if it is so costly to have compliances. That is why we agreed that, in Companies Act 2013, it was suggested that let the private and small companies have some flexibilities and freedoms, and compliance should be at a lower cost for them. Then companies with higher public interest, any company in which public is more interested, like it is the impact is more for the public in general, okay, where that type of companies, let us have a strict regime of corporate governance. Corporate governance is basically all the rules, compliances companies to follow. Then government companies and PFIs, public financial institution, let them also have same parameters like other companies. This part, if you remember, I have explained that initially they told that government companies should also have the same parameters like every other company. Means what rules you are applying for other companies, government companies also should follow that rules and compliances. This was suggested and this was done also in 2013. However, in 2017, there was an amendment. In that, they gave a lot of liberties to government companies. So ultimately, government companies have less compliances to follow. Then simplified regulatory regime, proper disclosures, etc. We have already gone through this. Companies Act 2013 was assented by the President and then notified in the Gazette on so and so date. The main idea for the Companies Act was the ease of doing business. People wanted the business should be done on a easy format so that everyone can do the business in a smooth way, so that people from outside are also interested to come and do business in India. This all we have discussed in the introduction class itself. Now the main chapter actually starts over here. Till now we were only talking about introduction, MCA, what is Companies Act 2013, why Companies Act 2013 came, about the J.J. Irani Committee and so on. Now we are actually starting the chapter from where questions will be asked. Okay? So we are going to study about the doctrines first. There are a few doctrines. The first doctrine being doctrine of ultrawires. Then we have doctrine of indoor management, constructive notice, and so on. Now let's study from doctrine of ultra wires. What is ultra wires? Ultra wires, basically ultra means beyond and wires means power or authority. Ultra wire means any acts that is beyond the authority of a company to perform. Say for example, you come to the classroom, so you can switch on light, fan and sit, right? But in the summer months, if you want to switch on the air conditioner, you generally have to take permission from the admin, whoever, if you want to switch on the AC. If you want to come and you want to switch on the AC, that act is beyond your capacity to perform on your own. You have to take permission. It is known as doctrine of ultra wires. Any act which is beyond the authority of the person to perform. Alright. Similarly, over here in doctrine of ultra wires, what we mean, any act that is beyond the power of the company to perform. There are certain things which company can do. Company can do means what? I will keep on saying this thing throughout. Company can do this, company can do that. But can company on its own do anything? Then it's not an alive person, right? Someone has to act on behalf of that company. Whenever I say company can do this, basically what I mean is board of directors can do it. Whenever I'm saying company has the power, it basically means board of directors have the power. So here when we are saying any acts which is beyond the authority of a company to perform, it basically means it is beyond the authority of the board of directors to perform. Okay, so board of directors can do certain activities. It has the authority to perform certain activities, and certain activities board of directors cannot perform on its own. It needs permission of someone. Whose permission? Shareholders' permission, correct? Certain things board of directors can do on its own, because who is giving that power to the board of directors? Board of directors get power from three places. Board of directors get power, one is from the Companies Act itself. Okay, Companies Act itself gives the power to the board of directors that you can do this. Other powers it can get from MOA or AOA. Memorandum of Association or Articles of Association also give certain powers to the board of directors that you can do this activity. Now, if these people are not giving the power to the board of directors, or sometimes these people itself will say that if you want to do this, take the approval from shareholders. Certain powers it gets from shareholders' approval. Okay, like memorandum of association will say, you want to borrow up to 5 crore, you can do it on your own. But more than 5 crore, take shareholders' approval. You're able to get this part? So this is how the board of directors gets its powers. But still there will be something which board of directors is not allowed to do, even with all these powers. Okay? So this is what is we are going to study in doctrine of ultra wires. What is ultra wires now? Yeah, beyond the power. Beyond the power. Basically, ultra wires, the exact meaning, beyond the capacity, beyond the powers of. In this case, we are talking about beyond the powers of the company. So ultra wires can be divided into three divisions. What are those divisions? Ultra wires, the company means the company cannot perform that activity. then it can be ultra vires the memorandum, then it can be ultra vires the articles. Now, generally, articles authority is at the bottom. Articles ke maal idana memorandum of association. If articles is not allowing, but if memorandum of association is allowing, company can do that. Articles is not allowing, memorandum is not allowing, memorandum ke maale, articles ke maale enna Companies Act. Companies Act is allowing, na, can do it. So ultra wires the company. Now first concept that we will study will be ultra wires the company. Any act which is done contrary. Contrary means what? Against. Okay? I am telling you drink water, but you are drinking milk. You are going contrary to me. You are going against. So any act done contrary to or in excess. In excess means what? I am telling you drink water. If you drink milk, it is basically going against. If I tell you drink water, drink 1 glass of water and you are drinking 2 glasses of excess. So that is known as basically excess of the scope of activity. I am telling you only this is your scope of activity and you are going beyond that. You are doing that also and a little more also. That is known as going in excess. Okay? So any act done contrary or in excess of the scope of activity of Companies Act will be ultra vires. And this act will become what? Void, and it cannot be ratified even by unanimous resolution of all the shareholders. Now, what is the meaning of this? What is the meaning of void? Void means what? Void basically not allowed. It is ineligible now. Such an act is void. If you have done that, we will not accept it. It is against. It is nullified. We don't allow it. We don't accept it. That is what is void. It cannot be ratified. What is ratified? Ratified basically mean it cannot be approved. Say for example, your family is against love marriage and you run away and you get married to someone from another community. Now you come back to your parents after the marriage, and then sometimes the parents are forced to accept it. Correct? They will throw you a reception party or something because you have already gone and done the marriage, right? This is what that act, for them it was void. But now if they want, they can ratify it. Ratify it is what? Now I can approve it. How they can approve? They will throw a reception party, they will accept you, they will let the girl come inside the house. This all is getting ratified. So ratified is basically I am approving it even if it was against the company. Even if it was against the company, such act is done, it can be ratified. But here what they are saying, if you are doing anything against Companies Act, that act cannot be ratified even by unanimous resolution of all shareholders. What do you mean by unanimous? Unanimous basically 100%. Unanimous means 100%. So of all the shareholders, say for example, there is a company called for example, there is a company called A Private Limited in which there are 20 shareholders. There is this board of directors of a company and it does something ultra vires the company. What can be that? It is ultra vires the company. Companies Act says that you cannot do activity against the law. Okay. So say for example, this board of directors tells that Another example I'll give you. If private limited means company can have a maximum of 200 shareholders. Okay? Written in the Companies Act, a private company can have more than shareholders. We will study about the definition later. So now board of directors says that minimum we have 300 shareholders. Okay, and it accepts 300 shareholders. Now what is this actually? Basically, ultra vires. Why it is ultra vires? Because companies do something which is against the Companies Act. Ultra vires the company. Now, if unanimous resolution, basically if you do this 300 shareholders, this activity will be what? Void. But even if you get unanimous resolution, all the 300 shareholders are saying yes, it is okay. All right. So this is what, can you ratify it? Ratify it. Can you approve it now? No, you can't approve it. Even if all the shareholders are saying it is okay, then also it cannot be approved. Why? Because it is against the Companies Act itself. Another example which you can take over here is, say the board of directors approves that we will now do, the company's main business will be doing smuggling. All the 300 shareholders agree, yes, we will do smuggling. Can it be correct? Does it mean that it is a correct thing? Void, it will still be ultra vires. Able to understand this concept? So basically, what is ultra vires? Ultra vires the companies if you do anything against or in excess of the scope of activity of the company, then it will be void. Even if it is ratified by unanimous resolution of shareholders, it will still be void because it is ultra vires the Companies Act itself. Shareholders together cannot go beyond the act, right? Just because 300, 500 shareholders tell yes, na, they cannot become above the act. So that is why it will still be ultra vires. Is this concept clear? What is ultra vires the company? Now let's see this. Board members are appointed or removed without following the statutory provisions. Payment of dividend out of, this is one example. Board of directors, there has to be a certain method in which they are appointed. If you don't follow that and shareholders tell it is okay, it is okay. No, it is not okay because you are going against the Company Act. If you are paying dividend out of capital, see, dividend has to be paid out of profits, basically, revenue profit. Dividend is a share of profit. You cannot pay it out of capital. So if you're paying dividend out of capital, it is also ultra vires the company, even if shareholders are okay. Reducing the share capital of the company without the proper legal formalities, the ultra vires the. Now second concept is ultra vires the MOA. Ultra vires is what? Beyond the power of. So first case what we studied was beyond the power of the companies. Basically you are going against the companies. Second thing what we are going to study over here is memorandum of association of the companies telling something, but you are going beyond that memorandum. Then what will happen? Let's find out that. So all of you know that a company has two charter documents, right? What are that two charter documents? Correct. Memorandum and article. Study about this in detail in the next chapter. Memorandum of association talks about the relationship of the company with the outsiders. And articles talks about the relationship of the company with the inside. So what is memorandum of association? Memorandum of association, it is a document which lists out the constitution of a company or country ki or constitution or company ki or constitution. So that a memorandum is basically a document talking about that constitution. It contains the clauses which details the boundaries of the company's activities and its relations with the outside world. So what is this telling? Memorandum of association will tell you the boundary. You all know the meaning of boundary, right? Boundary means what? Idike, this is the boundary. You should do your activity within this limit. This is my limit. In the limit ke velile you cannot go. The company is telling that you can do the business of, for example, Shilpis Academy Private Limited or memorandum irke. On the memorandum, it is telling Shilpis Academy can do business of coaching of professional courses in commerce. So this is the boundary of Shilpis Academy. What is the boundary of Shilpis Academy? Coaching of professional courses of commerce. Now, can I teach for NEET course? I cannot do. Why? Because my boundary in the memorandum is told as commerce. Able to understand this? So memorandum talks about the boundary. That idike outside you cannot go. So for example, if the memorandum of association of Shilpis Academy says coaching of professional courses of commerce. So professional courses in commerce நிறைய இருக்கு. CA இருக்கு, CS இருக்கு, CMA இருக்கு, ACCA, USCMA, CFA, CPA, அந்த மாதிரி CAT, CLAT, that is also a type of professional course of commerce. So நிறைய இருக்கு. But it is not required that I will do all the courses. I may just be doing CA, CS, CMA. I'm not doing CPA, CFA, all this I'm not doing. That is okay. Because memorandum is telling my boundary. It is not telling that you have to do all this. It's telling if you want to do, you can do up to all this. Are you able to understand? So I can do CA, CS, CMA and maybe later I can do CFA, CPA because it is allowed in my memorandum. But I cannot do NEET. If I want to NEET, I have to do NEET coaching now. I have to first change my memorandum. I have to alter my memorandum, increase the boundary, and then only I can. So it contains clauses which details the boundaries of the company's activity and its relationship to the outside world. The MOA restricts the power of the company while defining the object of the company. The main clause of memorandum is object. Object means what? What I told you just now, no? Shilpis Academy will do coaching of professional courses in commerce. Other than object. Company cannot do anything which is beyond the purview of the object clause. Any act which is done in contrary to the object clause will be, if I take from students fees for NEET coaching and say I will do NEET coaching, basically that is ultra vires. I cannot be void. As a result, an act which is ultra vires is void and does not bind the company. Neither the company nor the contracting party can sue on it. Such an act is void and cannot be ratified even by unanimous resolution of all the shareholders. So even this you cannot ratify. Any doubt in ultra vires of memorandum? Now ultra vires of memorandum, what? NEET coaching is ultra vires to Shilpis, right? One student comes and he gives the fees and says I want to do coaching only, and I take the fees on, but I don't do NEET coaching. So what? That student cannot sue. Why? Because student should have first checked the memorandum of association. In the memorandum and articles are supposed to be public documents. Are they supposed to be public documents? So memorandum and articles are supposed to be what documents? Public documents. Why? Because public can inspect this anytime. If any student has paid me for NEET coaching and I don't do NEET coaching, he cannot hold me liable. He cannot sue. Why he cannot sue the academy? He should have checked MOA that in that NEET coaching is not in the object of the academy, and I have taken fees for that. Basically, that is ultra vires MOA. So anything ultra vires MOA, no one can sue. And even if all the people agree also, if all the faculty say that no problem, we will do NEET coaching for this person, then also it cannot be done because it is beyond the capacity of. If you want to do NEET coaching, first what has to be done? First, you have to alter. How can MOA be altered? It can only be altered in extraordinary general meeting, the general meeting with shareholders' approval. Only then can alter MOA and then move forward. Otherwise, it is just. Is that okay? But now next concept is what? Ultra wires the AOA. This is the third concept. First was ultra wires the company, second was ultra wires MOA, the third is ultra wires AOA. What is AOA? It contains all the inside the company. Bylaws is what? Sub-laws, inside laws, regulation. Regulation, how will your relationship with the insiders? What is the relationship of company with shareholders, company with customer, company with employees? This is the article. So, memorandum will tell you can do coaching for commerce professional courses. Articles will tell this faculties will be responsible, this many faculty, their study material will be admin ke didana timing ke, this all will be the articles. How the delivery will happen will be mentioned in the articles inside rules. It will contain bylaws and regulations for what? For management of the internal affairs of the company. It plays a vital role in governing a company's affairs and defines the right of its members' interests. If a company acts which are ultra vires the AOA but intra vires the MOA, will be ultra vires the AOA. That is, this is very, very important. This only is a difference between MOA ultra wires and AOA. Once read this and then I will explain. Just read. Okay. So what is this paragraph saying? This is very important. If a company is doing something ultra vires the AOA, if MOA is saying something and AOA is saying something against it, all right? For example, interest for calls in advance. Have you heard about this calls in advance? Shares we will have no application, allotment, first call, second call. So there will be something called calls in arrear, but if we pay before itself, it will be calls in advance. So for that calls in advance, companies have to pay interest to the shareholders, right? Correct? So over here, say for example, MOA is saying that interest should be paid for calls in advance. Okay. But what AOA of the company is saying, interest should not paid at the rate of, or should not be paid higher than at the rate of 8%. You're able to understand what is happening? MOA is telling that interest has to be paid. AOA is giving the detail, it should not be paid, it should be paid, but it should not be paid more than 8% per annum. Now what is happening over here is, company is acting ultra vires the AOA. How? Company has paid interest at say 10%. Okay. but it is intra via the MOA. Intra via means it is within the capacity of MOA. MOA is telling pay the interest, so it is paying the interest, it is following the MOA. So it is going against the AOA. So what will happen in that is payment of interest at a rate higher than allowed by article. These acts are also void, but the company in general meeting may alter the articles by an SR. SR basically resolution, and ratify the unauthorized act. So now what will happen? Now say A Limited pays interest on calls in advance at the rate of 10% per annum. Now what has happened? This company MOA, it has followed, right? It is intra via the MOA, correct? But AOA, it has gone ultra vires, correct? Able to understand this part? So now if you're going ultra via the AOA but intra via the MOA, what will happen? This act will be still be void only. But what can happen now? Already I have paid the interest at 10% per annum. Ippo enna pannalam? Ippo enna pannalana? Ippo you have a general meeting. In that general meeting, all the shareholders to get resolution, which is known as SR in what is GM? General meeting. What is SR? SR is special resolution. What is special resolution? I will explain that once again. Special resolution basically means there is two types of resolution. One is OR, one is SR. What is a resolution? Whenever we are proposing something in front of the shareholders and they are voting and then it is getting confirmed, this part is known as the resolution. So say for example, we have already paid interest at 10% per annum. Now what the company will do, it will call a general meeting, it will ask the shareholders. Articles was saying 8%, but by mistake we have already paid at 10% per annum. Can you all please ratify this act? Approve this act? They'll be like, okay. Now what is OR? OR means votes in favor is equal to, actually you should write all this down. Votes in favor, always have a notebook for company law. Okay, company law means you need to write down notes. Please always have a notebook ready. You'll be writing down a lot of notes for company law. So votes in favor is equal to votes against. This is known as ordinary resolution. Sorry, I'm very what I was. Votes in favor is more than against. Votes in favor is more than votes against. So for example, if votes in favor is say 8 and votes against is say 7, that means it is passed by ordinary resolution, because votes in favor should be more than votes against. Now what is special resolution? Votes in favor is 3 times votes against. So if votes in favor is 12 and votes against is say 4, then this is special. So anything is ultra vires the AOA need to have pass a SR and ratify that act. You have to alter the articles. That is what is told over here. But the company in general meeting may alter the articles by SR and ratify the unauthorized act. So if you have already paid interest at 10% per annum, now what is the option? You cannot take back that money. You have already paid it to the shareholders, right? It is very difficult to take it back. So what will you do? You will call a general meeting and you will alter that article from 8% to 10%. Okay. By what? How will you alter it? By taking special resolution from the shareholders, and then that unauthorized act also will get ratified. Ratified basically approved. Okay. Whenever ratify words comes, no, remember that you are not allowed to get married into an outside community. You already do it and come back, and if your parents give permission, it is ratified. The doctrine of ultra vires was first enunciated by the House of Lords in a classic case of Ashbury Railway Carriage and Iron Co Limited versus Ritchie. This was a very, very classic case. Please go through this case in your Companies Act book. I will explain this to you in brief. What was this case about? So, there was this company called Ashbury Railway Carriage. So what had happened was that they entered into a contract with a company for laying down of railway lines. All right. In now, this company's object of memorandum was not to lay down railway lines. All right, but they took the contract with Ritchie. The memorandum, there was a word mentioned that they can be general contractors. But general contractors does not mean that you can take contract of laying down a railway line. So they had taken this contract, and then there were some issues. It was held that Ritchie could not get sued because what contract had happened between them was basically ultra vires the memorandum. They were not supposed to be doing the work of railway line laying down, and hence it was held that basically it was a case of doctrine of ultra vires because the company did something which is beyond the memorandum. I will just show this. We'll just go through this. Yeah, here is the case. Please go through this. Go through this paragraph. Basically, what is happening in this case is that Ritchie is a firm of railway contractors and they are financing the construction of railway line in Belgium. They bought a case for damages on breach of contract, but the word general contractors does not mean that they can enter into a contract for railway lines, right? The House of Lords, this is basically how the court called that time. The contract was ultra vires and hence it was null and void. If every shareholder also said that yes, it is okay, then also it cannot be ratified. Later on, it should be applied reasonably and unless it is expressly prohibited, they can do something for the attainment of object. However, even when the matter is considered necessary in furtherance of the object not stated, they would be allowed by the principle of reason random. Later on, things changed, okay, but however, this is held as a classic case that if it is mentioned as general contractors, you cannot enter into something which is ultra vires your memorandum. Then no one can sue you and neither can you sue. Ultra vires borrowing does not create a relationship of debtor and creditor. If a transaction is ultra vires the company, it can be decided on the basis of the following. Let's go. If a transaction entered into by a company falls within the objects, it is not ultra vires and hence not void. If a transaction is outside the object, it is ultra vires. If it is in excess or abuse, it is ultra vires, and it can be set aside by the shareholders or even ratified by the shareholders, would not validate the acts done beyond the authority of the company. So what is this telling you? The same thing which we have already gone through. If you do something beyond the capacity of the company, it will be ultra vires. It is within the objects of the company, it is not void. However, if you are doing something which is in excess of or abuse of the power of the objects of the company, then the shareholders can sometimes ratify it, or sometimes they are not allowed to ratify. They can basically, if you read the sentence again, it is ultra vires and such transaction will be set aside by the shareholders, or even ratification by shareholder will not validate the act which is beyond the authority of the company. If Companies Act is saying something and you go beyond the, you do ultra vires the company, shareholders also cannot ratify. Do ultra vires the articles, shareholders can ratify. If you do ultra vires the memorandum, it cannot be ratified, but the memorandum can be altered. Okay. Do ultra vires the company, no one can. This concept clear? Now, what is implied power? Implied basically means what? Implied basically means understood. Implied means understood. Okay, implied powers is, I don't have to specifically tell you that this is your power, but it is understood. Like specifically, I did not tell you when you enter the room, you can switch on the light and fan. This is your power. And the Madri, I did not tell you, right? But it is understood, no? You have the power to at least switch on the light and fan, right? That is what is known as implied power. Understood that this much power you will have. The powers exercisable by a company are to be confined to the object specified in the memorandum. Every company may necessarily possess certain powers which is implied, like power to appoint and act through. So company के memorandum or articles it is not mentioned that company can appoint someone or act through agents, but it is understood, no, that they can use a HR agency, or for digital marketing they can appoint an agent, or for representing their interest in court they can appoint a practicing CS and that can be represented. All is that company has the power to appoint and act through. Is that okay? Any doubt? Okay. Now, what powers cannot be implied? Certain powers, na, it is understood you have this power. Certain things, na, it has to be specifically mentioned. It cannot be just understood that you have this power. Okay. So, what are those things? This is important. Acquiring any business similar to the company's own business. Now, supposing Shilpis Academy Private Limited wants to acquire another business which is also into CACS coaching. Can we say that the company's this power is implied? No. Company's memorandum should mention this, that company can acquire business similar in its business. That line should be mentioned in the memorandum of. If it is not mentioned, company cannot acquire that business. That power cannot be implied, understood. Specifically, you have to be told. Are you able to understand this part? So in memorandum or objects le Tanya, it should be mentioned that company has the power to acquire business similar in nature. If it is not mentioned, you cannot just assume and acquire it. Is that okay? That power cannot be implied. It has to be specifically mentioned. So acquiring any business similar to the company's own business, entering into an agreement for partnership, taking share in other companies which have similar objects. For example, Pepsi wants to take some shares in Coca-Cola. Then this has to be mentioned in the memorandum that it can invest in Coca-Cola. Otherwise, it cannot. So this all is basically powers which is not implied. Not implied means it is not understood. You cannot just assume this powers. This powers has to be specifically given in the memorandum of association. What are these things? Taking share of other companies where investment authorizes the doing indirectly, that will not be intra vires if done directly. This point I will explain. Read the other points. Mostly you should be understanding all the points except point number 4 shall be explained. So taking shares of other companies where such investment authorizes the doing indirectly that which will not be intra vires if done directly. Basically, what does this mean? Pepsi and Coca-Cola are company having similar objects, right? So you cannot take shares in those companies. This is basically you are taking shares in companies whose object is different than yours. Say for example, this academy is going to do professional coaching of commerce. And then there is this company called Akash, which is only doing say NEET and IIT JEE coaching. Okay. If Shilpis Academy takes shares of Akash, alright, is taking shares of a company whose objects I could not do directly. If I do directly, na, it will be ultra vires, right? So that in this kind of shares also, if a company wants to take with another company, na, it cannot be an implied power. It should be mentioned in the memorandum of association. You cannot promote other companies or help them financially. You cannot sell the company's undertaking. You cannot use funds for political purpose. You can't do donation for charities. You cannot act as a guarantor for someone else's. Means company cannot act as a guarantor for someone else's loan. This Academy Private Limited acts as a guarantor for Shilpi Pediwal who is taking a loan. Company cannot do that until unless in the memorandum that power has. Powers are not at all implied powers. Okay? I hope this part is clear on powers which is not implied. Now, what is the effect of ultra vires transaction? What will happen if a company gets into transaction which is ultra vires? First of all, these acts will be null and void. If you do this kind of acts, it will not have any standing in the legal. Consider this act as null and void ab initio. This thing company will not at all recognize or follow. So this act is void. Company is not bound by these acts. Company cannot sue or be sued for these acts. They cannot become intra vires because of ratification. Just because the shareholders are ratifying it does not mean that this acts will become intra vires. The acts which is ultra vires, the act will be. Next part, so what is the effect of ultra vires transaction? Number 1, it is void. Company cannot or be sued. What is injunction? Injunction basically when some problem is going on, a case is going on, in between you get an injunction. So that means it will, the things will get stopped at that point. Okay, so injunction is basically restraining someone. Say for example, someone is building a house in the land which I, according to me, is mine. Someone started constructing. So I will go to court and get an injunction order. So court will stop that person from constructing further. That till the time we cannot decide whose land it is, you cannot construct it further. This is known as injunction stay order. We will. Members can get an injunction to restrain a company where Ultra Vires Act has been or is about to be taken. So members can basically get an injunction. Next is your personal liability of directors. It is the duty of director to ensure that the corporate capital is used for legitimate business, and if it is diverted to purpose alien MOA, if it is diverted to purpose and if it is diverted to purpose if it is diverted to a purpose which is alien to MOA, director will be personally liable to replace. In case of deliberate misapplication, criminal action can also be taken of. Fraud. If they exceed their authority, the same can be ratified by passing the resolution, providing company has the capacity to do that transaction as per its MOA. This is very, very. What are they trying to tell over here? Let's try to understand. So what are they telling over here? If what can be the effect of ultra vires transaction? Now, what is the duty of the director? He has to make sure that the money of the company getting used for only legitimate business, that is legal business, and whatever is mentioned in the object of memorandum of association. If they are using that money for something which is not mentioned in memorandum of association, then directors are personally. For example, the money of the company of Shilpis Academy Limited promote only commerce professional course. If I use the money of the company and start some real estate or construction activity, then what will happen? I am doing something which is against the memorandum, and I will be personally liable to repay that. In case of deliberate misapplication, purposely I have done this thing, na, criminal action also can be taken for fraud. If directors are exceeding their authority, the same may be ratified by passing resolution in GM, but it should have the company should have the capacity to do that as per MOA. Now, articles is saying MOA is saying that the directors can borrow money. Okay, what is the MOA saying? Directors can borrow money. AOA is saying directors can borrow money up to 5 crore. Beyond that, it should take permission of shareholders. Now, while borrowing in the course, the directors did not notice it properly, and they had borrowed 6 crore already. Directors have gone beyond their authority now, correct? But it is within the authority of MOA, correct? So what can be done? Ratification. That is what is this. The last paragraph is saying, if the directors exceed their authority, it can be ratified by passing a resolution. But company should have the capacity for that transaction in memorandum of association. Is that okay? Certain things director will be personally liable and they will be replacing it, but certain things will be ratified. Ultra vires borrowing will not create relationship of creditor and debtor. If I am borrowing money on behalf of the company for doing construction activity, it will be ultra vires. So it will not create a relationship of creditor and debtor. For example, I take as a director of Shilpis Academy Limited, I borrow 1 crore rupees, and you are like, for what is this 1 crore rupees? I'll tell that we are going to start a construction activity. This will not create a relationship and debtor, because you should have seen if Shilpis Academy, the MOA is allowed to do. It was not allowed, and still you gave the money for construction activity. You cannot sue me for that money. Neither I can. I am obliged. Company is not liable for torts outside its objects. Torts is basically frauds. If you do some fraudulent activities not in your object, company will not be liable. That's all. If you want to make the company liable for torts or crime of its employees, you have to prove that the crime was during the course of an activity which is in the purview of company's memorandum and it was done during his employment. If there is an employee, say for example, and he has done some fraud, and you want to prove that company is liable for this employee's fraud, two things you have to prove. Number one thing you have to prove is company, that employee was doing something which is according to the memorandum and it was doing it during the course of his employment. For example, two people come and you give the fees to Malika or Dip. They are allowed under the memorandum collect fees for the activity of CS coaching, correct? So this is what this activity is according to the company's memorandum. And when are they collecting the fees? During the course of their employment, correct? So you came, you gave the fees, they are in their course of employment, they are employees over here, they are doing it in the employment time and then they are taking money for an activity which is allowed for Shilpis Academy. It is under the purview of company's memorandum, correct? You gave the fees, they took the fees and now next day they run away with the fees and can I ask the fees again from you? My problem that my employee ran away, correct? But if supposing she is no longer an employee with me and it has been mentioned everywhere, still if you people pay the fees to her or if you people pay the fees to her for construction activity or buying stationery which is not in the object of memorandum of the company, then in that case company is not liable. Able to understand? Give money to Dimsha for something which is not CSCS CMA coaching, company is not liable for it. Is that clear? In ultra vires grants and guarantee, director cannot make unauthorized grant or guarantee. Same thing. As director of companies, you cannot give guarantee for someone else's loan which is not authorized. Then exceptions to the doctrine of ultra vires. What every concept in Companies Act has important exceptions. What is this exception? Any act which is performed irregularly but intra vires to company can be validated by shareholders in. So anything which is ultra vires the AOA or not done regularly, but it is intra vires the Companies Act, then directors validate. Company can validate by shareholders. For example, company does any act which is against the articles, but it is within the capacity of Companies Act. What the directors have to do? Call a general meeting, ask the shareholders to ratify it, allowed. This is known as exception doctrine of ultra vires because this will not be void. If any act is deemed to be an authority by Companies Act, even if not mentioned in AOA, it will not be considered as ultra vires. The Companies Act is allowing you something. Always remember this. Companies Act is first, next is MOA, next is AOA. So Companies Act is allowing you something. In MOA, it is not mentioned itself. Will you be allowed to do it? Yes, you are allowed to do it. Because who is on the top? Companies Act. Companies Act is allowing you to elect directors. Memorandum, no mention. Elect directors, will it be ultra vires? Not be ultra vires. Are you able to start? If memorandum, we cannot mention each and everything sometimes. If you are doing something which is not mentioned in memorandum, but it is mentioned in Companies Act, you can do it. Now don't confuse this with object. Memorandum object is mentioned. What is the object mentioned? Professional coaching of commerce. So that boundary is given in MOA. Now you cannot go against. You cannot say Companies Act will allow NEET coaching. No, I will do. No, not like that. Are you able to understand the difference? Memorandum has given you a boundary. So you can't go against it. But memorandum mention about a certain topic. Companies Act is allowing it. Then you can do it. It is not. Say for example, memorandum has not mentioned that directors can sign check or directors can be elected and these are their duties. But company exactly duties of directors they mention panita idi alladana duties. Apro, if you do something, are you able to understand? Next is any incidental effect of ultra wires will not be invalid unless expressly prohibited by the act. Incidental or consequential means what? You do some act and because of that something else comes up. It will not be invalid unless expressly prohibited by the act. Incidental or consequential effect means what? Incidental or consequential effect is like we are doing CS, we are teaching for CSCS. Now in that is a part of our act. Any incidental effect of ultra wires act will not be, 1 second, I'll give you a better example. Any act outside the authority of director but intra vires the company can be ratified by the shareholders of the company. This part I have already explained. Yeah, director is not allowed to do it, but company is allowed to do it. Then, if company does it, you get ratification of the shareholders. By what? You do a general meeting, get a resolution passed, mostly SR and GM, and then ratified. Director does something which